that means to me that that's probably going to be a claim in the bankruptcy, meaning paid by bankruptcy dollars, and the insurer will unfortunately have to take that loss. If it's a self-insured retention, it's more complicated because you have clauses I'm sure you're familiar with that discuss, that whether or not that retention has to be satisfied by actually payment or whether it's simply enough it's an obligation. And the insurer can take the position that it's not responsible until the self-insured retention has been paid by the debtor in full. And the debtor wouldn't be in bankruptcy if it could pay any of its obligations in full. So that creates a real sticking point. And it's been litigated fairly commonly, and the general rules that I would say come out of it is the bankruptcy court or the courts above them are not going to stick the insurer with first dollar liability if the self-insured retention can't be satisfied. They will fashion some sort of a remedy of a credit or something else to try and preserve the insurance for the survivor or for the third party claimant, and they will also not let the insurer walk away from its obligations if the self-insured retention isn't paid.
Ian, can I jump in and just make 2 quick points about that?
Please.
Thank you. So, number one, there are cases that make specific provision for payment of the deductible or self-insured retention, either on a percentage basis or sometimes in full, and that relates to and interacts with some of the things we've discussed before about, are there other parties like a parent company that has potential liability on the same claims? And so you get, for example, the Kaiser Gypsum case where the debtor's parent contributed tens of millions of dollars to a proposed trust for purposes of meeting its acknowledged deductible obligation so that it could access the next level of coverage. The second point I was going to make is ask yourselves how effective a credit or a set-off is in resolving cases in the tort system. Let's say you have a situation where the insurers have not settled, where the insurers will continue to defend claims in the tort system and pay settlements or judgments after the case is concluded. And let's say everybody agrees in response to insurer objections that there is a deductible or a self-insured retention that has to be provided for, but the debtor can't afford to pay it, doesn't have a rich parent company to provide funding for that. And then the plaintiffs say, well, I would have settled this case for $500,000, but recognizing that you're going to get a credit or a set-off for the $50,000 deductible, I will now settle this case for $550,000 because to me as a plaintiff, it's worth $500,000. And my $500,000 case is not going to go away for your $450,000 after taking credit for a $50,000 deductible. So Ian is quite correct that bankruptcy courts in particular will go out of their way to fashion a practical remedy that in the bankruptcy court's view does rough justice. But there is much to be debated about whether it actually works in the real world of settling these cases.
Yeah, it's an excellent point. And to that, the difference between the insured's interest, the debtor's interest, and the insurer's interest, the debtor doesn't really care if it can get out of bankruptcy and it has a claim made against it. The third-party claimant cares very much about what the disposition is of that insurance. And the insurer obviously is very reluctant to be paying out money that it is not going to get back in hundreds of dollars. So the real world is very different.
David, one of the things that you had talked about at the beginning for your clients is finality and certainty and having them be able to understand what their obligations are and the assets, et cetera. I want to make sure we have time for questions, but could you spend some time talking about the role of policy buybacks and coverage in place agreements and other sorts of agreements that might allow the parties to at least reach some understanding about how these policies are going to operate in the trust?
Sure. And by the way, that certainty is valuable for the trusts and for the claimants and for other constituencies as well. Knowing that I'm going to let the debtor get a discharge and a channeling injunction and not have any future responsibility for the liabilities means I need to be comfortable as a claimant that there are going to be resources there to compensate me and that I'm not